Prior to the agricultural revolution, there were likely few formal laws regarding landed property, as such concepts would be difficult to establish in nomadic societies. Many scholars believe that during this time, men tended to hunt more and women tended to gather more, but both roles were critical in order to gather the resources needed for a full diet the group could survive on. Studies of modern hunter-gatherer societies suggest women likely faced fewer formal restrictions based on gender. Childcare was likely shared across the group, as both hunting and gathering were activities that required time separate from the responsibility of parenting. Some scholars have argued women likely played a major role in the early plant domestication that led to the agricultural revolution in the Fertile Crescent, given their role in gathering and processing grains. But with an agricultural revolution came a shift away from nomadic cultures to a more sedentary farming lifestyle, and with it came significant changes in society. Perhaps the largest change being the need to protect specific areas from other groups, both in terms of farmland itself, as well as stores of food kept to feed the group in between harvests. As civilizations grew larger, they created legal codes which were enforced generally by armed men, and unsurprisingly, these laws seemed to be designed for the benefit of armed men. Under the Code of Hammurabi, dating back to around 1754 BC, women had fewer rights than men and were often treated under the law as subordinate to their father or husband. Marriage was more or less a contract made by the woman's father with her husband. The husband could ask for divorce, usually in exchange for returning the dowry, and often having to provide support after the divorce, while women could only seek divorce if she could prove abuse or neglect, and then only if she could prove this abuse or neglect in a court. If a woman failed to meet the burden of proof, she risked substantial punishment. Adultery was punishable by death for women, usually by drowning. If she was caught in the act, she and the man she was with would be executed together under Law 129, which ordered, quote, "If the wife of a man has been caught lying with another male, they shall bind them and throw them into the water. If the husband of the woman wishes to spare his wife, then the king shall spare the servant." On the other hand, if the husband were caught with a woman who was neither married or betrothed, there seemed to be little any direct penalty to him. Women could inherit and manage property and engage in trade, particularly as tavern keepers or in specific religious roles, but men were still greatly advantaged in law in most matters. Laws in Egypt gave women substantially more rights than the Code of Hammurabi. Egyptian women could buy and sell under their own name and often inherited equally with their brothers. They were able to initiate divorce and keep both the dowry and personal income, as well as appear in court and engage in contracts without any type of male guardianship required. Men did tend to dominate politics in Egypt, but women such as Hatshepsut and Cleopatra were still able to become pharaohs. Assyrian law was quite different, largely removing the rights from women and legalizing violence against them by their husbands. The law stated, quote, "A man may strike his wife, pull her hair, or bruise or pierce her ears. He commits no offense thereby. But, quote, if a woman has struck a man, and they prove the charge, she should pay 30 minas of lead and receive 20 strokes as rods." Even more explicitly, another law stated, quote, "If a woman in a quarrel has crushed a man's testicles, they shall cut off one of her fingers. If a physician binds it and the other testicle becomes infected, or if she has crushed both testicles, they shall blind both of her eyes." Even the protections of women were based on the woman's relationship to her husband rather than any rights she might be entitled to. For example, quote, "If a man has struck the wife of a man and they prove the charge, they shall cut off one of the fingers. If he has kissed her, they shall draw the lower lip down with a blade and cut it off." The law made clear men always received wealth and property before women. For example, quote, "If a woman be dwelling in the house of her father, and her husbands have died, any gift with her husband settled upon her, if there be any sons of her husbands, they shall receive it. If there be no sons of her husbands, she receives it." But at the same time, she would have to accept the burdens of her husband, with the law stating, quote, "If a woman be dwelling in the house of her father, but has been given to her husband, whether she has been taken to the house of her husband or not, all debts, misdemeanors, and crimes of her husband shall she bear as if she too had committed them. Likewise, if she be dwelling with her husband, all crimes of his shall she bear as well." Along the same lines, the divorce law stated, quote, "If a man divorces his wife, he may give her something if he wishes. If he does not wish, he need give her nothing." Wives were also to be veiled, with the law stating, quote, "The wives of a man, or the daughters of a man, who go out into the street must be veiled. A prostitute shall not be veiled. Her head shall be bare. A slave woman shall not be veiled. Whoever sees a veiled prostitute shall seize her. They shall inflict 50 strokes with rods, and pour pitch upon her head." By comparison, Mosaic law had less restrictions for men in terms of owning property or wealth. Women were able to inherit if there were no sons and could give inheritance. Rabbinic law still generally required male relatives in court, but they were allowed certain legal claims, especially involving marriage contracts or property. But proceedings were usually conducted through male representatives. In court, women were not allowed to act as witnesses. Men could request divorce for more or less any reason, while women needed permission from a rabbinic court. This permission had to be sought by a male guardian, submitted on their behalf, and would only be granted in specific circumstances. In ancient Athens, women were unable to sign contracts of any significant value, access courts, or participate generally in the democratic assembly. They could only request divorce if they were able to locate a male guardian who would advocate on their behalf, and if divorced, their husband would keep the children. Spartan women, on the other hand, were able to own property independently of men, as well as bequeath and inherit. In fact, Aristotle wrote that by his estimate, Spartan women owned between 30 and 40% of the land. But women were still not allowed to vote or hold office. In the early Roman Republic, women could not vote, hold office, and were functionally designated under the law as being under the legal control of either their father, husband, or some other male guardian whose formal approval was required for many legal processes, including those involving property. Children legally belonged to the father even after divorce, and divorce was very common, particularly among the upper classes. Initially, only men had the right to request divorce, but by the 2nd century, women were given limited rights to request divorce as well. These Roman restrictions on women did not exist in many of the areas that Rome attempted to conquer, which could lead to conflict. One example of these conflicts occurred in the British Isles, when the Celtic king Perseudagus, who had been allied with Rome, in his will left his kingdom to his daughters to be ruled jointly. Celtic law at that time did not have the Roman restriction on property ownership or inheritance for women, or even in terms of military service or general legal standing. In fact, around the same time in northern England, Queen Catamadra ruled over large parts of what is now northern England and had negotiated treaties with the Romans directly. But reportedly, when Perseudagus died, the Romans ignored his will. They not only attempted to annex the land, but they raped the king's daughters and beat his wife, Boudica. This led the king's wife to lead a revolt against the Romans. Boudica's forces won an early victory, destroying a Roman fort located near what is modern-day Colchester and forcing the Romans to flee. Boudica and the forces then continued on to Londinium, near what is now modern-day London, and burned that settlement to the ground as well. Her forces continued on to burn another settlement near what is now modern-day St. Albans. Roman accounts estimated that around 70,000 to 80,000 Romans were killed in the attacks, although most modern historians believe this number is an exaggeration. What most do agree on is that Boudica and her supporters' goal was to remove the Romans from the island entirely, rather than to take prisoners. The Romans were eventually able to bring additional forces to the island to put down the rebellion, due in part to Romans previously disarming many of the local groups in the years prior as part of peace negotiations. This was not the only time Rome found itself in armed conflict with women in positions of leadership. The First Illyrian War with Rome in the 2nd century began when Queen Teota was in power in the Balkans. Much of the discourse around the war seemed to be around it being unacceptable to negotiate with a woman, or for a woman to command a navy. In the mid-200s, when Zenobia declared herself queen of the Palabrian Empire in Syria, she conquered large sections of Egypt and Asia Minor, but Rome swiftly sent forces to remove her. While these conflicts were primarily based on politics and power, the narratives of the Roman accounts also makes it clear that the idea of a woman in power was seen as unacceptable to Roman law and custom. When Roman writing referenced women of the Samaritan and steppe cultures riding horses and participating in battles, they were labeled as barbarians, and shunned the customs of these cultures, allowing women to own property. Over time, the Roman Empire did loosen some of the restrictions on property ownership for some wealthy women, allowing them to own property, run businesses, and even lend money with the requirement of male guardianship over matters being more symbolic than legally enforced. For example, a wealthy businesswoman named Eumacia financed major public works in Pompeii and even had a statue of herself displayed there. But the law still generally prevented women from gaining or keeping lasting power. After Constantine's conversion to Christianity in the early 300s, Christian views on marriage as bond rather than contract influenced law. Divorce began to require more of a legal basis rather than just being the whim of the husband, and divorce without legal basis would bring financial penalties to the husband. The practice of abandoning unwanted children began to be punished by new laws, including women being able to request divorce in church courts if abandoned. The church also added some limited supports for widows that hadn't been provided prior, but generally it was in exchange for them giving their property to the church. These supports were also extended to the so-called brides of Christ, consecrated virgins who swore celibacy while working on behalf of the church. Because of these changes, women were also no longer forced to remarry by law to assure a male guardian at all times. As Roman influence declined, its legal restrictions on women were lifted in some places. The Visigoths allowed women to inherit land and property. The code stated, quote, "A woman shall be entitled to share an entire inheritance. Sisters shall equally with her brothers." Women could also represent themselves in court once they reached the age of 14, and even arrange their own marriages by age 20. They even allowed queen regents on occasion. Frankish law was less generous, but did allow some limited personal property rights, while still keeping restrictions on inheriting royal land. Anglo-Saxons allowed property ownership, and even had a few queens rule, but still limited women's rights around divorce. In areas of Europe that were never connected to Rome, they often had even less restrictions. In Ireland, Breton law allowed women to own property, and in many ways treated men and women more equally than other legal codes, but was still quite patriarchal. For example, the law allowed a husband to strike his wife to, quote, correct her, as long as he left no mark. If he did leave a mark, his wife was entitled to seek divorce and compensation. Married households could only disperse property with the consent of both spouses, which had become quite complicated as polygamy wasn't uncommon. Many Viking cultures also allowed women to own property. For example, during the earliest settlement of Iceland, as sub-settlers took possession of large areas, King Harald Finehair of Norway set rules about how much land you could take. For men, he said none should, quote, claim more land than he and his crew could mark off in a single day by means of signal fires. They should kindle the first fire as the sun was in the east, and then the other fires should be built so the smoke from one might be seen from the next. Those kindled while the sun was in the east must be kept burning till nightfall. Then they should walk until the sun was in the west and make other fires. For women, quote, it was decreed that no woman could take more land than she could walk around between dawn and sunset on a spring day, leading a 2-year-old, well-fed heifer. Legal restrictions on women were not exclusive to the West. In China, starting in 581, significant legal reforms made it incredibly difficult for wealth and property to be inherited by women over the male heads of household. Variations of laws asserting legal authority of the male head of household remained in effect through most of Chinese dynasties up to 1911, with some regional and social exceptions. Under tribal laws, women were also not able to inherit property in many parts of pre-Islamic Arabia. In these communities, marriages were often also controlled by tribal leaders. In some parts of India, women could hold property and other kinds of wealth given to them before marriage, but the rules could vary greatly around local customs rather than being fixed in law. In Africa, restrictions on women greatly varied from community to community, with some communities not allowing any property rights, while other communities having matrilineal systems over management. Matrilineal systems were also part of Iroquois traditions in North America. As Islam grew in the 7th century, Islamic law did entitle women to inheritance, but often only as half shares compared to men. The laws also indicated in some instances financial compensation for crimes against women could be half of what crimes were for men. In many Islamic legal traditions, a woman's father could give his daughter to a marriage without her consent, and a man could have up to 4 wives. Still, the ability of women to buy and sell property, own a business, and sue in court on their behalf existed, unlike in much of Europe and Asia at the time. Feudalism completely changed the concept of property ownership, functionally putting all land under the monarch, who then could grant land to nobles in exchange for loyalty and general military services. These noble landlords would then subdivide their lands into fiefdoms to vassals who would manage the feudal tenants, ostensibly in exchange for protecting them militarily. Under this system, land was generally transferred hereditarily, often to the oldest son. As a result, in many places, women's ability to hold property, the primary source of wealth at the time, was greatly reduced. Even in places where the rights were preserved, marriage became more and more transactional. Some scholars have argued that jewelry was prized by women and nobles not purely for aesthetics, but because it was one of the few transferable sources of wealth women were allowed to possess and transfer independently. One of the protection clauses that was demanded in the Magna Carta was from widows being able to keep an inheritance and not be forced to remarry in order to retain their inheritance and right as part of their husband's estate, known as a dower. It said also that she may be given 40 days to remain in the husband's home after his death to make arrangements. Even in the rare occasions where the law did transfer power and land to women, they would often find the laws changed suddenly to prevent this transfer. For example, in France in 1317, the only surviving child of King Louis X was his daughter Joan. Louis's brother Philip had the laws changed to make him king instead, and once crowned, changed the law so that only men could be crowned. Just over 100 years later, the Kingdom of France found itself at risk of conquest by the British. A teenage girl reported she had visions of herself fulfilling a prophecy of a virgin carrying a banner that would put an end to France's suffering. She began calling herself Joan the Maiden, designing her own banner, rallying and leading French forces against the English invaders, asserting that she had been sent by God to restore the French monarchy to Charles VII. Her forces were successful in restoring the French monarchy, but she was captured and put on trial for heresy. She was accused of blasphemy for wearing men's clothing, and her visions were condemned as demonic. While the trial was conducted after her capture by the British, all but 8 of the 131 clergy who participated in the trial were French, albeit most in opposition to Charles VII. At least one bishop wrote to the French king asking him to aid her, stating failure to do so would demonstrate, quote, monstrous ingratitude. But the new king seemingly ignored the letter, and the trial proceeded. At just 19 years of age, Joan, known to history as Joan of Arc, was found guilty as a heretic and burned alive. Urbanization began to create new opportunities for business based less on property ownership, and women were able to create shops and businesses, and in some instances even join trade guilds. There were many women who worked as midwives, often engaging in general medicinal practices as well. Over time, these women became vulnerable to accusations of witchcraft, with people either claiming treatments were magical in nature or that failures to heal were done with malicious intent. But simply failing to comply with societal norms or questioning church authorities could also make a woman a target. A German clergyman by the name of Heinrich Kramer was acting as a church inquisitor when he filed charges against a woman after she stopped attending his sermons. She told him, when he asked why she stopped attending, that she believed his sermons were heretical because his entire sermon was focused on witches. Kramer said that she gave it as an example, quote, added that I had given the method of striking a pail of milk in order to gain knowledge of a sorceress who had taken milk from cows, and when I stated I had cited these things against them by way of a censure rather than an instruction, she stated in the future she would never attend my sermons after release. He held an inquisition which accused 13 people of witchcraft. A local bishop had to intervene to stop him. The bishop wrote of Kramer that he was, quote, presumed much that had not been proven, and Kramer was, quote, completely childish on account of his age. But Kramer was not deterred by this setback. He would go on to write Malleus Maleficarum, a book which had 20 published editions and was widely read. He traveled and gave sermons and training sessions to other inquisitors and was named a papal ambassador by Pope Alexander VI in 1500. Kramer's focus was almost entirely on women, writing that women have, quote, temperament toward flux, and that women were more lustful than men. He also wrote, quote, a person of bad reputation and shameful habits of faith is easily defamed as a heretic. Indeed, it is a general rule that all witches have been slaves from a young age to carnal lust and to various adulteries, just as experience teaches. He wrote, quote, women therefore is evil as a result of nature because she doubts more quickly in the faith. In 1540, Henry VIII granted a charter to the Company of Barber Surgeons, ostensibly to professionalize the healthcare industry. But in practical effect, it put a barrier to entry for midwives and other women who had been central to healthcare prior to the change. English law also specifically developed a concept known as coverture. Jurist William Blackstone explained the concept by writing, quote, by marriage, the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended during the marriage, or at least is incorporated and consolidated into that of the husband, under whose wing, protection, and cover she performs everything, and is therefore called in our law French a femme couvert. It is said to be couvert baron, or under the protection and influence of her husband, her baron, or lord, and her conditions during her marriage is called her coverture. Under this principle of a union of a person in husband and wife depend almost all legal rights, duties, and disabilities that either of them acquire by the marriage. I speak not at present of the rights of property, but as such are merely personal. For this reason, a man cannot grant anything to his wife, or enter into the covenant with her, for the grant would be to suppose her separate existence, and to covenant with her, and would be only a covenant with himself, and therefore it is also generally true that all compacts made between husband and wife, when single, are voided by the same intermarriage. Much later, Supreme Court Justice Hugo Black would write of coverture, quote, the rule is worked out in reality to mean that the husband and wife are one, the one is the husband. Under this concept, any money or property received by the wife was the property of the husband for all intents and purposes under the law, and unmarried women were generally not given the full rights of men to control their property and wealth. This concept was part of the legal frameworks of the expanding British Empire, including the United States and India, and similar concepts requiring women to have male guardianship through the law were also widespread throughout the rest of continental Europe and their colonies. It was in this context which Abigail Adams wrote to John Adams in 1776, quote, in the new code of laws which I suppose it will be necessary for you to make, I desire you would remember the ladies, and be more generous and favorable to them than your ancestors. Do not put such unlimited power into the hands of the husbands. Remember, all men would be tyrants if they could. In writing Remember All Men Will Be Tyrants If They Could, Abigail Adams was likely referencing an essay John Adams himself had written and shared with her, but not yet published. John Adams replied, quote, as to your extraordinary code of laws, I cannot but laugh, We have been told that our struggle has loosened the bands of government everywhere, that children and apprentices were disobedient, that schools and colleges were grown turbulent, that Indians slighted their guardians and Negroes grew insolent to their masters. But your letter was the first intimation that another tribe, more numerous and powerful than all the rest, were grown discontented. This is rather too coarse a compliment, but you are so saucy, I won't blot it out. Depend upon it, we know better than to repeal our masculine systems. Although they are in full force, you know they are little more than theory. In 1804, the Napoleonic Code abolished the old traditions of inheritance, favoring the oldest male, but still stated that a married woman could not dispense of, contract, or transfer property without her husband's consent. In 1811, in Sweden, in some limited circumstances, unmarried women who owned their own businesses were allowed to make financial decisions independent of a male guardian. In 1821, in Maine, the legislature passed laws giving women some property and financial rights in the event their husband was incapacitated. In 1839, Mississippi allowed women to own property in their own name, but control still remained with their husband. In England in 1839, women were granted the right to request custody of their children in the event of a divorce. In 1840, to have consistency with Spanish and Mexican law at the time, the Republic of Texas allowed married women to own property in their own name. In 1842, Sweden made their compulsory elementary school laws also apply to women. In 1845, married women in Denmark were allowed to write personal wills without the approval of their husband. In 1851, Illinois opened its first hospital for the mentally ill. The law required a public hearing before anyone could be committed to this institution against their will, with one exception: if a husband wished to commit his wife. This exception remained in effect until 1867. In 1855, the University of Iowa became the first coeducational public university in the United States. In 1858, the Ottoman Empire allowed women to legally register and inherit land in their own names. In 1864, the Supreme Court of North Carolina ruled in State v. Black that, quote, a husband cannot be convicted of battery on his wife unless he inflicts a permanent injury or uses such excessive violence or cruelty as indicates malignity or vindictiveness, and it makes no difference that the husband and wife are living separately by agreement. In 1868, when the United States wrote the 14th Amendment to expand citizenship and voting rights to former slaves, the amendment explicitly used the word male when describing who receives additional rights. In 1869, the Wyoming Territory granted universal suffrage, including women. A year later, in 1870, a judge in the Wyoming Territory allowed women to serve on juries, but this only lasted for 1 year before the judge was replaced. In 1890, the Wyoming Constitution, submitted for admission to the state, stated, quote, in their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal. Since equality in the enjoyment of natural and civil rights is only made sure through political equality, the laws of the state affecting the political rights and privileges of its citizens shall be without distinction of race, color, sex, or any other circumstances or conditions whatsoever other than the individual incompetency or unworthiness duly ascertained by a court of competent jurisdiction. The rights of citizens in the state of Wyoming to vote and hold office shall not be denied or abridged on account of sex. Both male and female citizens of the state shall equally enjoy all civil, political, and religious rights and privileges. In 1870, England passed the Married Women's Property Act, allowing women to keep money they earned and inherit property in their name, but only within limits that remained in place until the law was expanded in 1882. In 1871, Japan allowed 5 women to travel to the United States to attend school, including college for some, but still forbid them from attending universities in Japan itself. In 1872, Sweden passed laws limiting arranged marriages, with a somewhat ironic exception for the nobility, which permitted their marriages to be arranged until 1882. In 1873, the United States Supreme Court ruled in Bradwell v. Illinois that the Illinois State Bar Association could refuse the admission of Myra Bradwell, based purely on her being a woman. In 1876, the United Kingdom repealed laws which prevented medical license from being issued for qualified women. In 1881, in France, women were allowed to open savings accounts in their own names, and in 1886, married women were allowed to do so without the consent of their husbands. In 1908, the United States Supreme Court ruled women did not have equal rights to negotiate contracts in Muller v. Oregon. The decision stated, quote, woman has always been dependent upon man, and, quote, the limitations which this statute places upon her contractual powers, upon her right to agree with her employer as to the time she shall labor, are not imposed solely for her benefit, but also largely for the benefit of all. In 1909, France granted married women the right to be consulted by husbands before family property was sold, and to press charges against the husband for mismanagement. In 1910, in the United States, the Mann Act made it a felony to engage in any interstate transport or commerce to, quote, any woman or girl for the purpose of prostitution or debauchery or any other immoral purpose. The vague language of this law allowed the act to be used to charge even consensual sex between adults until it was amended in 1986. In 1916, a high court in India ruled women could not be allowed to practice law, despite citing an 1879 act which stated the word person. This was reversed in 1923. In 1918, Australia removed laws that prevented access to a number of professions to women. However, that same year, the Northwest Territory passed laws which stated all Aboriginal women were under the control of the Office of the Chief Protector of Aborigines until married to a man who was, quote, substantially of European origin. That same year, a new Russian constitution declared equal rights for men and women, and the UK gave women over 30 who owned property the right to vote, and for women over the age of 21, the right to become members of Parliament. The following year, they passed the Sex Disqualification Removal Act of 1919, which allowed women to access all professions and the ability to sit on juries. In Germany in 1919, the Weimar Republic declared men and women to have equal rights. However, this was functionally revoked by laws passed by the Nazis in 1933, which purged women from a number of civil service, academic, legal, and medical professions. In 1920, China allowed women to attend universities, and that same year, the United States passed the 19th Amendment, giving women the right to vote. In 1922, the Married Women Independent Nationality Act passed, allowing American women to marry non-citizens without losing their citizenship, as prior it was understood she would assume the citizenship of her husband. This was the same year that women in Japan were permitted to attend political gatherings, but still could not vote or join political parties. It was also the year the Soviet Union removed laws which made marital rape legal. In 1923, Egypt made education compulsory for both sexes. In 1926, Turkey granted equal rights to women in matters of inheritance, marriage, and divorce. In 1931, Chinese women gained the right to equal inheritance, choose their marriage partner, file for divorce, and control their property after divorce. In 1932, Ireland banned married women from working in the public sector. This law remained in effect until 1973. In 1936, Iran outlawed the veiling of women. Police were ordered to physically remove the veils of women who did not comply, and many women were beaten and their scarves removed. This law was removed in 1941. In 1943, Spain changed the age that the woman was considered an adult to be 21, and even at that age, an unwed woman could not leave the home without her father's permission until the age of 25. In 1944, laws were added requiring her husband's permission to seek employment. Spain also passed so-called honor-killing laws that stated parents could kill their child with minimal consequences if they were caught having sex with a man while she was under age of 22. This law remained in effect until 1963. In 1948, the United States Supreme Court upheld a Michigan law which forbade women from working as bartenders in cities with populations over 50,000 people unless their father was the owner of the bar. The court said this was acceptable as bartending might, quote, give rise to moral and social problems against which it may devise preventative measures. This decision was not overruled until 1976. Starting in 1953, in Afghanistan, the age of marriage for women was raised to 16. Dowries were made the property of the wife, and some women were appointed to be judges in family courts, as well as given greater access to professions such as flight attendants, police officers, and telephone operators and receptionists. In 1964, the Constitution of Afghanistan gave equal rights to women in terms of education, employment, and marriage rights. In 1965, the laws that forbid French women from working without the consent of their husband were lifted. Australia ended their ban on married women working in 1966, and Germany repealed their laws in 1977. In 1974, American women could no longer be legally required to have a male cosigner to open up a bank account. However, marital rape was still legal in parts of the country until 1993. In 1979, Saudi Arabia mandated that all women must wear a veil in public. Iran followed suit in 1981. Saudi Arabia has since loosened enforcement requirements of the veil law starting in 2019, but the laws remain on the books. Iran has not loosened restrictions, and the Taliban in Afghanistan, starting in 1996, added veil laws along with numerous other laws restricting women. These laws were lifted for a time during the American occupation, but were fully reinstated in 2022. History is awkward.